The judge lifted a large, glossy color photograph of my front door, as though it were the smoking gun in a capital case. "Let me make sure I have this correct," she said, peering over the rims of her glasses with deliberate calm. "Is this navy blue door with the window in it? Is the entire foundation of your lawsuit?" On the other side of the aisle, the HOA's lawyer adjusted his tie with a practiced flick. "Your Honor, it's far more than just the door," he insisted smoothly. "The roof pitch is wrong, the siding material is wrong, and the window style all incorrect." But the judge cut in, tilting her head. "He doesn't even live in your neighborhood. That's the part I'm having trouble wrapping my head around." In the front row, HOA President Cynthia Malloy gripped her three-ring binder like it was the only thing keeping her afloat in a sinking ship. Her name tag, Maplerest, HOA President, practically glowed with authority. She leaned forward, voice tight with barely contained outrage. "His so-called dream house sits directly across from Maplerest," she snapped. "You can see it from our cul-de-sac. It obliterates the entire uniform aesthetic we've worked so hard to protect. We're only trying to enforce consistency." My attorney slid a thick document across the bench with the exhausted elegance of someone who had reprinted the same exhibit far too many times. "Your Honor, if you'll turn to page 2, he said quietly. "This is the official recorded plat map. The heavy black boundary line is the Maplerest HOA. The small gold star marks my client's property." The judge studied it in silence, her eyebrows rising millimeter by millimeter. "The star," she finally said, "is plainly outside the black line." "Precisely, Your Honor," my lawyer replied. "That's Cedar Hollow Township land, not the HOA. They're attempting to sue a man who never agreed to their covenants, who doesn't live inside their subdivision, and who built entirely within county code simply because they disliked the color of his front door." Cynthia shot to her feet, cheeks flushed. "It's not just the door," she practically shouted. "It's the whole non-compliant monstrosity. Our uniformity is under attack. Our property values are at risk." The judge set the plat map down, pressed 2 fingers to the bridge of her nose, and let out a long, weary breath. "Miss Malloy," she said, in a voice that could slice marble, "you are asking this court to force a man to alter or tear down his lawfully built home because it offends your sense of visual harmony even though your rules have zero legal jurisdiction over his land." She paused, letting the words settle like dust. "And I have a strong suspicion you're not going to enjoy the next 5 minutes." Before my house became public enemy number 1 to the Maplerest Homeowners Association, it was simply the place I'd been dreaming about for a decade. My name is Aaron Cole. I write code for a living, work from home, own more flannel shirts than TIs, and my social tolerance tops out at roughly 2 people at a time. I like quiet, tall trees, and neighbors so far away I can't tell whether they're watching football or a nature documentary by the bass vibrating through the walls. For 10 solid years, I saved every extra dollar for one goal: a house built exactly the way I wanted it. No beige vinyl siding, no plastic shutters nailed to brick for no reason, no random Tuscan arches in a county that's never been within 2,000 miles of Tuscany. When a perfect 5-acre wooded lot popped up on Ridgeway Road, I pounced. It sat immediately past the edge of a brand new development called Maplerest Row upon identical row of gray-beige houses, all wearing the same porch lights, the same mailboxes, the same HOA-approved landscaping. Their fancy stone entrance sign proudly declared, "Welcome to Maplerest, a uniform community." In hindsight, that should have been my red flag. But the listing was crystal clear: Incorporated Township, no HOA, zoned R1 residential. Pure Cedar Hollow Township county rules, not city bylaws. Freedom, not micromanagement. I hired a surveyor to double-check every inch. He pounded stakes into the ground and sprayed blazing orange lines across the dirt. "You're good," he told me with a shrug. "Your back tree line practically high-fives their fence, but you're outside their plat. Different jurisdiction. Their HOA has no power here. Can't touch me," apparently sounded like a dare to the good people of Maplerest. Enter Cynthia Malloy, early 50s, razor-sharp bob, blazer every single day, why, including weekends. Her favorite pastimes included power walking the sidewalks with a clipboard, reciting covenants like Bible verses, and dropping per the CC and Rs into every conversation as though it carried the weight of federal law. She'd been president of the Maple Rest HOA for exactly 16 months and acted like she'd been elected to the Senate. Her crowning achievement to date? Banning any inflatable holiday decoration taller than 4 feet. Her neighborhood was her empire, her covenants, her constitution, and she was not about to let my non-beige rebellion rise unchallenged on the horizon. Trouble began the moment the framing went vertical. My design was a modern farmhouse hybrid dartboard and batten siding, oversized black framed windows, and a standing seam metal roof that would sing when the rain hit it. To me, it was perfection. To Cynthia, it was apparently the architectural equivalent of a middle finger. I was on site measuring a doorway when she came marching up the driveway, binder clutched like a riot shield. "Excuse me," she announced, in a tone that suggested no one had ever actually excused her in her life. "Who approved this? This thing?" "My architect, the county building department, and common sense," I answered, pointing at the bright orange permit nailed to the nearest pine. "I mean, the Maple Rest Architectural Review Committee," she shot back. "I'm not in Maple Rest," I said. She blinked twice, processing, then glanced over her shoulder at the pristine stone entrance, where a perfectly symmetrical boxwood was wilting dramatically in the July heat. "You're within visual range of the community," she declared, as if she'd just invented zoning law. "That brings you under the spirit of the CC and Rs, if not the exact letter." "That's not a thing," I replied. She jabbed a perfectly manicured finger toward my half-finished porch. "Our guidelines strictly prohibit dark exterior colors and metal roofing. Any structure visible from Maple Rest must maintain aesthetic continuity with the community." "Lady," contractor muttered from behind me. "This here is Cedar Hollow soil. Your HOA's authority ends at that back fence, and not an inch farther." Cynthia gave a dismissive little sniff. "We'll see about that," she said. And reader, when an HOA president says, "We'll see about that," what she really means is, I have just promoted this to my new full-time, unpaid career. Then came the letters. The first one showed up in my temporary job site mailbox while we were still waiting on the plumber. Official notice of non-compliant construction. It was printed on heavy cream stock that probably cost more than my first car payment. "Dear property owner," it began, "your ongoing construction is in direct violation of Maple Rest community standards, including, but not limited to, unapproved exterior color palette, unapproved roofing material, unapproved fenestration style, and unapproved architectural massing. Cease all work immediately, and submit full plans to the Maple Rest Architectural Review Committee within 10 calendar days." I wrote back on a sheet of printer paper with a Sharpie, "Dear Maple Rest HOA, I am not now, nor have I ever been, a member of your organization. Best, Aaron Cole, definitely not your resident." They answered by escalating. Suddenly, I'd spot board members in khakis and polos standing at the edge of my lot with tape measures and clipboards, calculating the exact distance from my future front steps to their stone entrance sign like they were surveying the DMs. The guy listed on their website as Landscape Compliance Chair was literally walking my tree line, counting trunks. One Saturday morning, heard branches snapping in the woods behind the foundation. I walked back there and found Cynthia herself, heels punching holes in the soft dirt, phone held high, taking pictures of my roof trusses. "You're on my property," I said as calmly as I could manage. "I'm documenting an ongoing violation," she fired back without lowering the phone. "On property that is not yours," I repeated. She finally looked at me, eyes narrowed to slits. "Anything visible from Maple Rest affects Maple Rest, Mr. Cole." "Good to know," I said. "I'll let the squirrels know they need to submit their acorn coloring plans for review." Things went from annoying to outright unhinged fast. A drone showed up one afternoon, buzzing in slow circles above the roof, like it was casing the place for a heist. My framer got a cease and desist on actual law firm letterhead threatening all available legal remedies if he kept installing that forbidden metal roofing. The private Maple Rest Facebook group, which I obviously wasn't in, but screenshots travel faster than gossip, lit up with threads titled, eyesore update, and protect our property values. My personal favorite comment: it looks like a Bond villain ordered a house from Pinterest. I kept building. I had stamped permits, passed inspections, and a county inspector who cared about load-bearing walls, not whether my siding matched the neighbor's soul-crushing beige palette. Ignoring them was easy in theory. In practice, Cynthia treated silence as a declaration of war. When polite letters, passive-aggressive emails, and surprise visits failed, she did what every power-drunk HOA eventually does. She sued me. The complaint landed on my doorstep in an envelope so thick it made a solid thud. Maplerest Homeowners Association, Inc. v. Aaron T. Cole. My stomach dropped as I read it on the porch. They accused me of willful violation of recorded architectural standards, creation of a visual nuisance, irreparable diminution of the uniform character and property values of the community, and my favorite construction within the intended extraterritorial aesthetic governance zone of the association. Translation: make it beige or tear it down. I drove straight to my cousin Nate's office. Nate actually practices real estate law instead of just yelling on Nextdoor. He read the complaint, took off his glasses, wiped his eyes, and laughed until he wheezed. They filed suit against a guy who doesn't live in their subdivision, he gasped. This is the legal equivalent of McDonald's suing your backyard grill because your burgers aren't wrapped in branded paper. Can they actually win? I asked. Anyone can file anything, Nate said, catching his breath. Winning is another matter, and these people are about to discover the difference the hard way. He filed an answer that was basically 3 pages of, he doesn't live there, you have no jurisdiction, please go away and stop wasting everyone's time. Maplerest doubled down. Board minutes leaked, thank you. Anonymous screenshot angels showed Cynthia rallying members. If we allow one outsider to defy uniformity, the entire community collapses. They poured dues money into lawyers, who spoke of community character like it was the Bill of Rights. And then they made the mistake that ended them. Desperate to prove my lot was secretly inside their kingdom, they attached to a filing their own revised plat map. Somebody had clearly opened Microsoft Paint, scribbled extra wobbly lines around my property, and labeled the new territory aesthetic buffer zone. Nate held the official county plat in one hand and their crayon masterpiece in the other like he was comparing the Mona Lisa to refrigerator art. They tried to expand their borders with the laptop stylus, he said, voice trembling with second-hand embarrassment. We overnighted copies of that filing to the county prosecutor, the township supervisor, and for good measure the state agency that regulates homeowners associations. Because when you start forging maps to steal someone else's land, the adults finally notice. 2 weeks before trial, the mood inside Maplerest shifted from righteous fury to cold sweat. The board fired off an emergency email that leaked faster than a Civ 8 minutes flat. It was a masterpiece of spin, regrettable legal misunderstandings, overly aggressive outside parties, protecting the community we all love, but you could smell the panic between the lines. Turns out the county prosecutor really doesn't like private organizations photoshopping official plats and waving them around in court filings. The state attorney general's office liked it even less. Their letter to the HOA was 2 paragraphs long and ice cold. We are in receipt of credible allegations that the Maplerest Homeowners Association has asserted governing authority over non-member properties and submitted falsified boundary documents in active litigation. Produce within 10 business days every plat, amendment, governing document, and related communication in your possession. Failure to comply will result in further action. Then the insurance carrier called. Their D&O policy apparently didn't cover suing people you have no legal right to sue. The treasurer reportedly whimpered. We're just trying to protect uniformity. The adjuster replied. Uniformity doesn't pay 6-figure sanctions, sir. Nate pounced. He amended our filings with counterclaims, abuse of process, slander of title. Their lis pendens had clouded my deed. Trespass, all those clipboard safaris through my woods, and intentional infliction of emotional distress. Overnight, Maplerest went from plaintiff to defendant with actual exposure. Residents finally did the math. Someone snuck a phone into the next closed board meeting and recorded the whole meltdown. A guy in a faded Cubs hat stood up. So let me get this straight, how much of my money are we burning to force some guy's house to match our approved shade of greige mist? The treasurer wiped his forehead with the napkin and muttered, legal expenses are necessary to defend property values. Another voice shouted, how much is necessary? Answer, 70% of the entire discretionary budget. 70. The video hit every local Facebook group by sunrise. Comments were brutal. 400 a year so. Karen can play Supreme Court. Your dues hard at work, photo of my house looking gorgeous. HOA speedrun, any to bankruptcy. By the morning of the trial, the narrative had flipped. I wasn't the villain anymore. I was the guy their board had decided to financially immolate over a metal roof. Which brings us full circle to the courtroom, the glossy photo of my Navy door, and the judge, fighting a visible battle not to laugh out loud. Nate walked through it like a PowerPoint titled, How to Lose a Lawsuit in One Easy Step. Deed in my name. Official plat. My lot clearly outside the black line. My chain of title. Zero mention of Maplerest covenants. County permits. Stamped, inspected, approved. Then he clicked to the final slide, the HOA's homemade plat with the wiggly extra border labeled Aesthetic Buffer Zone. Your Honor, either this is performance art, or it's fraud on the court. The judge called the county clerk to the stand. We'd subpoenaed her for fun. The clerk looked at the HOA's exhibit, looked at the official record, and gave a single, definitive head shake. That document has never been recorded in my office, and we do not recognize aesthetic buffer zones as a legal encumbrance in the state of Ohio. The judge turned to the HOA's attorney, voice like dry ice. Counsel, who prepared Exhibit D. The lawyer looked like he wanted to be literally anywhere else. It was provided by my clients as a conceptual illustration of intended influence. You attached it to a sworn filing claiming it proved jurisdiction, the judge said. The courtroom temperature plummeted. Cynthia shot to her feet. Your Honor, everyone understands the community's influence extends beyond, ma'am, the judge cut in. Sharp enough to draw blood. Your influence extends exactly as far as your recorded documents allow. You do not get to annex land because you dislike the siting. She shuffled her notes, then delivered the verdict slowly and clearly, so even the court reporter could feel it. Complaint dismissed with prejudice. Translation, don't ever bring this garbage back here. Furthermore, I find this action constitutes frivolous conduct and abuse of process. Defendant Aaron Cole is awarded full attorney fees and costs, to be paid by Maplerest HOA within 30 days. Cynthia actually squeaked. Finally, the judge continued. The submission of an altered plat map is hereby referred to the State Bar for investigation of potential ethical violations, and to the Attorney General's office for review of the association's governance practices. The HOA attorney closed his briefcase like a man sealing his own coffin. The judge fixed Cynthia with a look that could curdle milk. Miss Malloy, homeowners associations are not sovereign nations. You do not get to redraw boundaries because someone built a house you find personally offensive. I strongly recommend Maplerest reevaluate its leadership and its priorities. Because right now, your obsession with uniformity is costing your members far more than a navy blue door ever could. The gavel cracked like a gunshot. Cynthia stood frozen, white as printer paper, clutching her binder while the residents behind her frantically opened their calculators to figure out exactly how much this catastrophe was going to raise their dues.